Continuing our coverage from the Mass Torts Conference in the Wynn Hotel in Las Vegas, Nevada, I'm joined by Linda Lipsen. She's the CEO of the American Association of Justice. Linda, welcome to the program.
Thank you.
Give me a sense of what you do as the CEO of the American Association for Justice.
One part of what we do is I run a trade association of thousands and thousands of lawyers, and we help them represent their clients by giving them education programs and magazine and materials so that they can bring justice to their clients. But another very big aspect of my job is to go to Congress and help educate Congress on why the courthouses of this nation should continue to be open for ordinary people who are just seeking a fair chance.
Now, and I think that notion of keeping the courthouse doors open to people, I think that this audience has heard that phrase, but what does it mean in sort of a practical level, and what are the forces aligned to prevent citizens, and why are those forces aligned to prevent citizens to having access to the courts to get some type of redress?
Many companies believe that they should not be held accountable for the harms that they sometimes cause. Whether it has to do with a dangerously defective car or a defective drug, you name it. And so what they do is they go to Congress and they seek what we call tort reforms to make it sometimes impossible for ordinary people to get compensated when harms come to themselves or their families.
I mean, I've told people, when you hear the words tort reform, you should react in the same way you do when you hear the words entitlement reform. It means something is being taken away.
Yeah.
Some right, some benefit is being taken away from essentially ordinary Americans. And we should say, it's not a question of belief for these corporations, right? It's really just simply a function of mathematics for them.
Well, I always say that they can fix this problem by making products safer, and they can fix it themselves rather than spending hundreds and thousands, if not millions and millions of dollars on lobbyists and PR firms to try to convince America that they are the victims. They need to look at their drugs and say, you know what, we've got a problem in this drug and we're going to make sure that it's fixed rather than waiting for thousands of people to get injured. What happens is there's a rationalization that occurs in corporate boardrooms throughout the country. Same old story happens over and over again, where a small fix of, let's say, a gas tank or an ignition switch, a small fix, not a lot of money, would cause a product to be safer so that no one has to go to a courthouse. That's the kind of reform that we need.
But I mean, do they make the calculation, like you say, a small fix won't cost that much money? Isn't it the calculation in their minds, like, it costs us $10 per unit to fix, whereas $7 per unit, we already have our in-house counsel. Anybody who comes up against us, we can quash them because we have an in-house counsel. We could do this for 10, 50, we could push this off in 30 years into the future. And me as a CEO, it's not going to affect the stock price, my stock options, the board of directors behind me, they get paid the same way. Their compensation is all part of that. We're going to do a big buyback. It'll create shares in our values. So if we can, at the very least, punt this 30 years in the future and it's a $7 expense then, or even if it's an $11 expense as opposed to a $10 expense now, $11 30 years out as opposed to $10 now, it's just a business decision.
These are immoral conversations that occur in boardrooms. They occur in emails and documents, and it should stop. What we need to be doing is, instead of letting the buyer beware, we should protect the public against dangerous products, and no one has to go to court.
I'm glad you raised that, because one of the things that over the years on this program, I've had the opportunity many times to have little debates with libertarians, and many of them believe we should have no government regulation, that we can simply have the tort system to reconcile these issues. If you commit fraud or you harm me in some fashion, I'll just go to court and I'll sue you and I'll win, and people will know not to buy your product anymore, et cetera, et cetera. We don't need any regulations. address that idea? Like, why won't that work?
Because we need checks and balances in this country. And what has occurred over and over again is, the reason why we have safer cars, the reason why we have safer air, safer water, is because trial lawyers who pursue litigation on behalf of their clients to give justice back to their clients, they're telling the agency, hey, you've got a dangerous product here. Maybe you should take a look at it. If you look at and this is a wonderful thing. If you look at cars now, they're safer now than they were in the 50s. Despite the fact we have fewer accidents now than we did in the 50s because we have airbags, anti-lock brakes, seat belts, roofs that don't crush upon impact. And these all occurred because trial lawyers were vigilant. They informed the agencies, and then the agencies took the ball and ran with it. But it's really a system of checks and balances that we have to keep alive, or else the safety of individuals will be undermined.
Yeah, give me more of a sense of that relationship between trial lawyers and regulation, because to what extent, so the way you just described it there, it is you have attorneys going out there finding problems that are systemic problems that agencies then look upon and say, hey, this is a systemic problem. We need to protect Americans. We're going to edify this in rules based upon the statutory authority we have to. Does it also start, to what extent could trial lawyers also exist without some type of framework of government regulation? Or do they use that framework of government regulation as sort of a stepping stone too? Is there
they could exist, but it wouldn't be as beneficial as a system that is complementary, where you have government regulation on the one hand and litigation on the other hand. A really good example, I give you two examples, has to do with the GM ignition switch. That defect was not known because the agency.
Some people may not even know of the defect. So tell us.
Well, it's a defect within the ignition switch itself that causes the over-acceleration and the accidents that occur. And many people have lost their lives because of this little problem within the ignition switch. And it took an engineer and a lawyer in Georgia to say, look, something doesn't look right with this particular injury. I'm going to look into it, and they then alerted the agencies. The agencies then became very involved in it and started to regulate. And now individuals throughout the country know about the dangers and can protect themselves of the dangers. And also something that just happened with the Consumer Finance Bureau. In the Dodd-Frank legislation, there was language that said you should do a.
Well, I wanted to. You know what? Let's hold on for 1 second on the CFPB, because I do want to get to that. But in terms of, is that GM situation, is that an issue of failed regulation, or is it simply an example of the limitations of our regulatory state in that they don't have the resources to uphold regulations in many respects, and they need to rely on sort of these
There's a problem with the regulatory structure in that there's a revolving door involving regulators that go on and become part of the industry themselves. So there's that problem. There's also no independent testing that occurs, and that the information that regulators get often comes from the industry that they're regulating. So these two together cries out for, you need another body to be involved, and that's comes with litigation at the state level, and then the regulatory system can act in a better way. You could have a system, if you had all the resources in the world, where you would just have a super regulatory body, and then you wouldn't necessarily have the need for trial lawyers.
Right.
But that's never going to happen.
Right.
So this is a system that does work, sometimes better than other times. But in no agency is there independent testing going on. It's all about.
And to a certain extent, we see also this dynamic incredibly so in the securities arena, where the Attorney General's office, to the extent that anything's been brought by the DOJ or even state attorney generals, to the extent that anything's action's been brought, it's been based upon stuff that's been developed through discovery in private
That's right.
and civil proceedings.
That's right.
All right, we need to take a break. We'll be back in just a moment with Linda Lipsen, the CEO of the American Association of Justice, because I want to talk about the Consumer Financial Protection Bureau.
Okay.
They've just come out with a very important report. And I also want to ask you about just sort of like identity theft. I have one question on identity theft that because I got a letter the other day, and you may not have the answer for me, but I figure why not ask you since we're here. I am with Linda Lipsen. She's the CEO of the American Association of Justice. Linda, we've been talking about the role of plaintiffs' attorneys, trial lawyers. I say trial lawyers because I frankly think that the American public needs to understand just how important trial lawyers are.
I appreciate
It's too
that.
easy for the right to demonize these people because frankly, it is in their best interest to make sure that Americans don't have these advocates. And regardless of why, and it's been interesting when I come to this conference to sort of see the relationship between the financial interests of these people, trial lawyers, if they do well, they're going to make a lot of money. But also, there is a very deep commitment, like one that I can appreciate both in terms of social justice here and a deep problem with bullies. And a lot of corporations function as bullies in the country.
That's why I got into this in the first place, because I've always hated bullies. And, consumers throughout this country, all they're trying to do is get a fair shake. And companies come up with incredible ways to prevent them from getting the compensation that they deserve if their products are faulty. Like they have come up with this program called forced arbitration,
right,
which is now in every contract, pretty much every contract that you enter into involving a large consumer purchase, whether it's a cell phone or mortgage on your house or whatever it is. In the fine print, tucked in the fine print, is language that says, in the future, if something happens to you, you're going to have to go to arbitration, and the arbiter is going to be decided by the company that caused the injury that you're alleging. Now, that is just un-American and unfair.
Well, it's ridiculous. I mean,
Exactly.
it's basically saying like any agreement I enter into, we're going to go to someone
It's
who
just
is
completely unfair.
Other than the fact that I'm going to choose who it is,
Right.
they're going to be completely impartial.
Right.
And yes, it's a joke. And I don't think most people who sign these contracts have no idea that this is embedded in the contract.
Right.
To the extent that anybody is aware of it, they don't understand the implications of
Exactly.
it. And on top of that, I would say that the American public is not aware of the broader implications of this, which is basically saying we are letting atrophy set in on our entire judicial system in this country. We are basically fundamentally stripping the American public of their ability of redress.
Right.
And all of these issues are going to be resolved on the terms by the personnel of the corporations. All right, so that's a good lead in. I want to get to this Consumer Financial Protection Bureau report, because this is one of the best agencies, I think, in our government today. And there's a lot of reasons behind that. But before we get to that, I want to ask you this sort of personal, it's not that personal.
That identity theft.
I have received, in the past month, I've received a letter from Anthem, which is my insurance company, I guess, or they handle it from my union, saying that my name and Social Security, my 2-year-old son's name and Social Security, my 9-year-old daughter's name and Social Security number, my wife's name and Social Security number, and other, I guess, whatever other details they have on me, have been probably accessed, along with apparently 40 million other Americans.
Exactly.
And they said, there's really nothing to worry about, but we want to offer you this low-end, version of
Protection.
LifeLock. And it's free for you, it's for 2 years, which in and of itself, it's like, I've read that is not going to help me or my son, my 2-year-old son, with someone. Second of all, 40 million, I don't care how enterprising criminals you are, they may not get to the S's for 2 years, or 2.5 years, and they're still going to have my Social Security number. It's all going to be the same
And what if your
information.
medical records are released in that way?
I mean, I'm actually less worried about my medical records, it just so happens, than I am
About your Social
identity
Security.
theft. And it seems to me that there's a million different ways. They don't need my social security number, and if they so desperately need it, they could store it in some database off-site and give me a number, 5, and then they take it into their database, and 5 is associated with Sam's social security number. Who's going to do?
It's a huge problem, and and several of the companies are asking Congress to provide them immunity when these breaches occur. And we actually, the House Judiciary Committee is right now considering such a bill.
Right now?
Right now is considering such a bill, and
because they must be aware, because like if I'm thinking, hey, there's 40 million Americans out there, the damages involved in this, I mean, it's going to take me at least 10 hours to just to go out and spend, I don't know, $800 annually to make sure that I have some semblance of protection. I'm going to have to do my due diligence to pursue this because they offloaded the expense of their keeping it safe. And they wanted their convenience to be able to access my social security number. And they basically put the cost and the risk on me.
Right. There needs to be a system that would encourage companies to do the most they can to provide the security that their customers need.
Can we sue them?
You can sue them now, but they're trying to prevent that.
Because they're getting a sense that people are going to be like, hey, wait a second.
People are saying, there have been several companies that have engaged
big
in...
retail companies?
Exactly. I believe Target's one of them.
Right.
And yes, and people are very upset about this. And so instead of fixing it, which is what should be the response is this knee-jerk response. Let's go to Congress and figure out how we can evade responsibility. And that's just wrong.
Right. And then it seems to me they get that legislation, all they're going to do is whatever amount of resources they put towards their security now.
Right.
Why would they continue to put those resources in there?
In other words, it's the consumer that's ultimately subsidizing the corporate entity, because the corporate entity should be the entity that protects the public. I mean, it's
it
backwards.
Should be implicit.
It's
if you're going to take my
backwards.
social security number, you're implicitly saying to me, I mean, look, for my podcast, people sign up through PayPal. I don't take their credit cards, but I go to PayPal, which is, frankly, pain in the butt. And they take a hefty percentage out, but I do that because they have the most security. I could probably figure out how to take their credit cards, but I don't know how secure I could make it. And then I'm offloading.
No, it's a very serious issue. The House is dealing with it right now.
What are the chances that legislation is going to pass?
Well, the Democrats voted against the bill in committee yesterday, and
the Republicans voted for.
But again, I'm slightly optimistic because this is an issue that affects all Americans. You don't have to be a Democrat to have your data breached.
Right.
And so...
this is one of those things that are...
It's possible.
It's completely indefensible unless you don't have to defend it. It just happens on the sly, very quietly. Somebody drops it into the back end of like a budget bill.
That's why people have to inform themselves, because there's all kinds of maneuvers that are going on that can frankly hurt consumers, and they've got to be vigilant, and they got to pay attention, and they got to be informed. So, and your program goes a long way in doing that.
Let's talk about the Consumer Financial Protection Bureau. They came out with a big report. Tell me what that report was.
Basically, the report is addressing the issue of forced arbitration, which is this rigged system that companies engage in when you sign up. Like, for instance, if you bring your mother to a nursing home and they give you this huge contract, it's many, many pages. Tucked in the fine print is a line that says if something happens to your mother or your father years down the road, you're going to go through forced arbitration. And the arbiters are going to be selected by the company. So let's say your mother has Alzheimer's and she gets out of her memory floor and walks across the street, gets out. They're supposed to protect people in a memory floor, walks out and gets hit by a car. The family is in so much grief and so angry and never wants it to happen to another family ever. And so they try to file a lawsuit. And then they are confronted with the fact that 5 years before that, they signed an agreement by which she has no right to their mother has no right to a jury trial and has to go potentially thousands of miles away to an arbitration that is just rigged.
Right. So
and,
if it's
and what CFPB did is say, by the way, only 9% of all consumers that are involved in these arbitration agreements ever get compensated. So it's just completely unfair. It's not cheaper. All of the arguments for arbitration, that the companies have raised, have been debunked in this hundreds of pages report that came out from the CFPB. So it's a very good document, and I think it's going to cause the CFPB to actually engage in a rulemaking that will say this: that arbitration is fine, but it has to be voluntary. So that when a contract is entered into, that's not the time that you decide on what your remedies should be. It's when your mother walks out and gets hit by a car. And after that, then there should be a discussion of what the remedies should be.
So that you could actually negotiate, okay, yes, I'm willing to go into arbitration, but we both have to approve of the arbitration.
Exactly, it has to be mutual, and that's fair.
Because the response that some people would say is like, well, look, if you don't like the contract from that rest home that you're putting your mother in, don't sign it, don't go there.
Well, I actually can
what
tell
do
you...
you say to those people?
Well, the problem with that is that these are really unconscionable contracts because you potentially are going to the only nursing home in the area, and they have the only bed in the area for your mother, and so you don't have a lot of choices. So it's not you have no meeting of the minds, and there's no balance.
All right, so let me just clarify something. When you say unconscionable, you're not using that as a layperson. That's a legal term in terms of the quality of the contract and how a court would view the legitimacy of that contract. Explain
I say how a court should view that arrangement.
I mean, explain to people just that notion of unconscionability in the context of contract.
Unconscionability means that you're not of equal bargaining power. You don't have a choice. It's shoved down your throat, basically. You have to accept it. If you are signing your mother up for a nursing home, and let's say you X out the language. Let's say you get through the whole contract, which is pages and pages long. You X out the language. What occurs is the next day you're going to get called from the nursing home legal department, and they're going to say, by the way, we're not. Your mother isn't coming to our nursing home unless you sign this thing. So it's really, it's kind of like a contract. They call it in the law a contract of adhesion, where it's just unfair at the inception. Now, unfortunately, a lot of the courts have not viewed it that way. Recently, what they do is they're looking at, and I don't want to get too technical, but they're looking at the Arbitration Act, and they're saying that the Arbitration Act preempts
the Arbitration Act of
sorry.
Was it? I mean, is it a recent act?
No, it was passed years and years ago. That was only supposed to be used for businesses, but between businesses
okay,
because they're of equal bargaining power,
right.
Not between your mom or your neighbor and a big corporate entity.
So is this something that needs to be? So in other words, and let me just recap for people here. So there's the Arbitration Act that was originally intended to be a mechanism to relieve courts of dealing with conflicts from a business-to-business perspective.
Exactly.
Because these businesses are both savvy. They both enter into a situation where they have some form of roughly the equal bargaining power. They both have the capacity to have a team of lawyers to look at this stuff. They both have there is a symmetry to the amount of knowledge that they have because
I think that's the right word, symmetry. And balance. Here, you don't have a choice. I mean, if you're going to get a cell phone, you're gonna be faced with these kinds of clauses. And in addition, some of them are now saying, in addition to saying you have to go to forced arbitration, they're saying you can't enter into a class action.
That's right. In California,
that's outrageous too, because if you are just injured, let's say you discover that your cell phone company is charging you $5 more a month. You can't file a lawsuit because it's not economical to file a lawsuit. So you need to band together with other people that have the same injury so that you can change the behavior so no one in America ever has to get ripped off like that.
So can the CFPB via rulemaking simply say that arbitration clauses are not kosher, or do they need statutory authority? And to the extent that they have the rulemaking ability, do they already have the statutory authority embedded in the act that created the Consumer Financial Protection Bureau?
They can certainly make a stab at preventing forced arbitration in some financial products.
And then what happens
the
Chamber of Commerce sues in the First District Court in D.C.?
We'll see. But the CFPB has made a really good first step at this. And my understanding is that rulemaking will follow. And we're guardedly optimistic that the CFPB is going to come out with a rule that's going to protect consumers of this nation.
If people want more information on these issues and broadly speaking what the American Association of Justice do, where should they go?
They should go to takejusticeback.com.
Linda Lipsen, CEO of the American Association of Justice, I really appreciate your time today.
Thank you.